that standard of living, right? What is the life that the cat was accustomed to? And I don't even know if the $3 million will cover the life that the cat was accustomed to. Luckily, she's got a couple jobs of her own, right? And so she's out there. And that's where that trust really comes in, because we're not waiting for a judge to determine whether the $3 million for the cat is reasonable or not.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome to another episode of Life's Third Act. We thought it'd be fun this episode, and maybe a second episode. We'll see how much time we take talking about this. But we thought we would talk about something that's fun and interesting, I think, and that's about strange wills. Now, you can imagine that when people are preparing wills, that there's lots of opportunity for mischief. And it also is an occasion that brings out sometimes the strangest impulses that we have, things that during our lifetime we might have been reluctant to say or do or request of others or express as an opinion. Those things that people put in wills, they often feel a liberty that perhaps if they were present physically during the reading, they may not have felt the same liberty. On the other hand, in some cases, as you'll see in these examples, it's the opposite of that. I mean, these are people who had strong opinions and they reflected those through wills. But some are just odd. So this is a bit of a miscellany of items that we've seen or cases that we've read about relating to wills. And we thought it would be interesting to talk them through. And there's also some practical value here. We always try to find, whenever we talk about these things, some opportunity to learn. So we've kind of focused on that too. Now, John, being the diligent, studious lawyer that he is, he took the time to look into these cases pretty well. I mean, that you have to dig back, because some of these go back a number of years, these cases. In fact, a few of them hundreds of years. And yet there's an interesting story there. So I'm very impressed that John Sauter, many of you know, he's our senior attorney at Cordell and Cordell's estate planning group. And he takes the time to look at these things in a way that, quite frankly, I haven't had the time to do, but he has the interest and, of course, the expertise. So he brings to this discussion something that you don't find elsewhere when you talk about these cases. And there's a lot of discussion about these cases because they're interesting. And you can find mention of some of these on the internet, but you can't find the sort of backstory from a lawyer's perspective that John can bring to this. Now, on the other hand, let me issue this disclaimer. We do want to move through these at a reasonably good pace so that we don't waste your time. And so it does mean we can't go very much into the woods on these, but we do want to add a little more texture than you could find anywhere else on the internet regarding these strange wills and strange cases. So with that, John, are you ready?
I'm ready.
All right, let's plunge forward. Why don't you lead us off? We're going to talk about Jeremy Bentham. Is that right?
That's correct. He was a English philosopher back in the 1700s, and he passed in the 1800s. What they call that? The 19th century, right?
Yeah. Well, yeah. The 19th.
You always got to think about it, right? And he's an interesting character because his will had a lot of direction on what he wanted to happen with his body. Okay. And the interesting perspective when I think about this is currently a will isn't where you would direct what would happen with your body, right? That's a state thing. And in Missouri, we call it the right of sepulture, which I always love when we use the old Latin. And in that instance means the right to the body. But here, he was an interesting character. He was a philosopher, but he was a legal philosopher. And he was a big believer that the common law wasn't fair to the ordinary person, right? A lot of what we see in the law is in statutes now. There's a difference between statutes and what case law or common law is. And a lot back then, though, there wasn't a lot of legislation, maybe like today. And the law was written in these books that only certain people could access, and so he was a big believer in getting rid of that. But what he did with himself, right, is the University College of London has his preserved body in a glass box, okay? And so he's a big science guy too. He donated his organs to science. So he left his body to this physician. And that physician took the organs, closed him up, preserved him. Now, a little aside, at some point the head decayed. So what you're seeing when you go to London now is a wax head on top of his actual body.
Oh my gosh.
Right.
I guess there's no way to preserve the head in the way that undertakers do the body.
I don't know much about that, right? They may call us doctors of the law, but that's about where it stops. But the really funny thing here is he asked that at the university where he was really involved, every year when they have their annual board meeting, they actually wheel his body in. Okay, they take it out of the glass, they bring it in the board meeting, and then if you look at the minutes, it says present but not voting. Right?
He called this an auto icon or something.
Yep, just means an image of yourself in Greek, right?
Well, he was a strange character, and my familiarity with him was actually and is actually relating to economics. I mean, he famously, did these calculations that predicted that the Earth was going to run out of space and resources for human beings, and that this was this ticking time bomb, population time bomb. So he's the most famous in history for this occasionally recurring panic that we've seen from time to time. We've even seen it in the 20th century. Now I think we're seeing the opposite, where we're recognizing we have a population shortage. But the error that he made, though he's regarded as a brilliant economist as well as philosopher, a lot of the things he wrote, influenced economics even today. He had this theory about labor and the correlation between labor and compensation and reproduction and whatnot. A little bit of that tied in with his theory about population. But anyway, he proved really wrong, and his mistake was that he couldn't foresee, and this is understandable, that we had the capability with technology and science to accomplish what we have. The known laws of the world as he saw them, as they existed then in the 17th and 18th and 19th centuries, was that there was no way to deal with the fact that you had so much productivity per acre of land, and that was all you could extract from it. We didn't foresee, these vast capabilities today. So some people are a little harsh in judging him for lacking the foresight that there is technological development in the future that addresses what are often crises in the present day. But he was brilliant. But he was obviously pretty eccentric, and the fact that this was honored, and symbolically apparently still is honored, says something to his reputation.
Yeah, and his presence, right? He couldn't predict the future, and yet he's here.
That's a good point too.
And that's, right, we talked to people about estate planning. You can't foresee what's outside of your universe. You make a great point there in that you can only see what you know, and things change beyond what you could even expect.
Yeah, and incidentally, that's a good argument for people who really try to control through trust, and trust, we're a big fan of at Cordell and Cordell, and they do marvelous things. But it is true that you can try to control things in a way based upon what you understand at the time that you pass, and it turns out that things change dramatically, or it turns out that you're wrong about certain assumptions. So it's all the more important that when we are drafting trust, that we try to strike that balance between, you do want the level of control or direction that you think is necessary to assure the well-being of your loved ones for decades to come, or maybe a generation to come. But you have to be careful about how precise you make those provisions. So shall we move on to our next candidate for discussion?
Yep.
And I think this is pronounced Luís Carlos de Câmara.
It's Portuguese. I'm not really great at Portuguese. A little Spanish,
Okay.
But that might actually make me worse.
Well, our viewers will forgive us. So now I have to tell you, I know nothing about this guy. So give us an overview.
Yeah, he was a Portuguese aristocrat, right? Had inherited his money, as we would call it now, old money, right? But he didn't have any kids. He never got married. And he had the ability, therefore, to control where his property went. And this is something interesting. People ask me every once in a while, if I were to move somewhere, would it change what happens with my estate plan? In the United States, generally, no, right? We all honor each other's laws, the state's a state. But if you move to another country, the systems are way different, right? And so in Portugal, wills aren't used as much. Why? Because if you're married and you have children, automatically your heirs receive 2/3 of your estate. And you can't overcome it with a will or any other document, right? It's like that elective share.
Wow.
Right. We see it here as spousal, right? In Missouri, we've got the 1/3 spousal election. If you try to disinherit your spouse, they can always come back and elect a share through probate. But here it's 2/3. It's a huge amount.
Well, there is a public policy argument for that. If the assumption is made that your relatives, your loved ones, and primarily those who are descendants, so children, grandchildren, et cetera, parent, and also ascendants, parents, grandparents, if the law assumes that the means of support for these people would be otherwise the state, if it's not provided through the family, then they would have an incentive to assure that resources are made available to all the people that you bring into the world and that they bring into the world. Mm-hmm. It is a theory that kind of makes sense from the standpoint of public welfare and public resources.
Yeah, protecting them. Well, and there's also the reality that if you don't take care of them, the state will have to, right?
And that's the point.
Yeah. And so he was, so he has nobody to direct it, and this is when we do our estate planning. So these can be some of the hardest estate plans to put together because it's not clear from the get who's going to get your property, right? And so you get to decide. And Luís was having so much trouble with this question that when he went into the notary, right? And so notary is also something that's different country by country. Here, the notary is actually the one that manages the wills and writes them. And so he goes in the notary to write his will, and he cannot determine where it goes, right? He doesn't have a charity that's his favorite, no ascendants or descendants, right? He's left alone. And so he picks up the phone book and just randomly pulls 20 names out. And those 20 people become his beneficiaries. They actually receive his estate because there's nobody to receive the 2/3 election. And he gets to determine where it all goes. And he didn't do a lot. He lived off the money that he had gotten, but there was still a substantial amount left, like I think a 13-room apartment in Lisbon, and there was some substantial items here. But what it made me think of modern day, there was a woman in here that had gotten the call from the lawyer. Hey, you're named in Luís's will, and she's thinking, there's no way, right? I have no idea who you're talking about. I don't know why I would be named in the document. And all I kept thinking is all of those emails I've got from Nigerian princess, right? Could any of those have been valid if I would have looked a little deeper? Probably not.
Well, who would have thought that they could be a recipient in this way? So you could see why people would be really skeptical. But I kind of respect this approach. How common is it? And we have to say today, with people not having as many children, more people choosing to have no children, it's probably not that uncommon today to have people who are trying to figure out what to do with their estate. And I know you see this every day, at least several times a week, where there's somebody in this position who's choosing to give money to a charity, which is a worthy solution. But this guy's solution isn't bad either. If there's enough money to benefit, even if you were to take the money and assume there was 1/10 of that amount available, so you have 1/10 of the recipients, so you have 7 strangers. I think most people would want to say, well, I don't want to do strangers, but the idea of 7 people who would never expect it, who may not have what they think is a special relationship with me at all, but who I respect for some reason or I regard as needing or worthy in some way. I mean, I like the idea. I think the idea is really attractive, but I don't think I've ever seen it. Have you ever seen anybody give things to strangers, people that even almost strangers, people that maybe they know of and they respect or they think it's a need? How often do you see that happen?
I've never seen it, and I've witnessed it and overseen many estate plans. Something of note here is this was just 2007, right? We're not talking some 200-year-old story. This happened in modern day, and there was a friend of his that actually witnessed it, and he said that Luis's comment was, "I don't care who it goes to, as long as it doesn't go to the state. They've been robbing me my whole life, and I don't want them to get anything upon my passing."
Well, that's a sentiment that our clients share, but I have to say I haven't seen this either, and yet it's not that rare for us to have a client who gives everything for lack of alternatives or just simply as a reflection of their passion, their priorities. Will give everything to a charity or a number of charities. But this is really different. And I do like it where, again, not complete strangers, but I get it where you identify people that you know something about and you have a reason. And they may know you, but nothing more than simply knowing you and you knowing them. We're taking out in this example where you give to somebody who may be a friend is very close to you. That's not unusual. We're talking about a case where it's not a good friend. It's somebody that, again, maybe you know. In this case, he didn't know him, but I really do like this concept.
Quite a blessing in these people's lives. In the least, it would make a great reality TV show.
I was just thinking Hollywood's missing an opportunity here to make a movie about this.
Then the mystique of the Portuguese aristocrat, too, I think adds a little something to it.
You know, that is an interesting thing, how they, and I don't want to get started down this road because I could easily get caught up in discussing how this would be set up if you were to have some sort of show in which people who choose to do this, you follow what happens thereafter. The bottom line is people who watch our show should consider, if you don't have loved ones, then think about people who may not qualify as a loved one, but who you think you'd like to bless in a way that would completely shock them.
And potentially change the arc of their life.
In place, you could use trust too, to assure that this person who may not have the ability to manage money, you don't want it to go in the direction of a lottery recipient. We know how bad that is. So for people who are given a significant amount of money, they would definitely, in my opinion, want to use a trust to do it.
Definitely.
Yeah, great concept. So let's move on to Charles Vance. Is it Millar?
Yeah.
Millar?
Mm-hmm.
Okay, tell us about Charles.
Canadian lawyer and financier. He was really big into finance, but he owned a lot of businesses too. He actually owned a brewery. He owned a racetrack. And he was really involved in his businesses. I mean, he lived for it. Again, similar to our Portuguese aristocrat, no family, no kids, right? And as we've talked about, that's when things get interesting, right? What are we going to do here? And he was a little bit of a comedian, okay? He liked to play practical jokes on people. He actually, as far as we talk about it, a lot of us lawyers work until we go. And this guy passed at the boardroom table. He was 73 years old, working till the moment he passed. But they discovered his will shortly after, and it had a lot of different provisions in it that we can talk about. The biggest one and the most interesting is this 10-year, what they call the Great Stork Derby in Canada. Okay. And this was not forever ago that this occurred. And what he did was he said, well, it was 1930s. I'm sorry, I was looking at that wrong. But what he did was he said in his will, from the date of my death, whatever woman can birth the most children in the next 10 years wins a portion of my estate. And this became public. It was publicized really heavily. And so it was in that area where he lived in Canada, there was a rise in the birth rate because of this great race. And a bunch of women participated. Can you guess at what the number was of children that won?
Of less than 10, I would think.
Right. 9. And there was 4 women that split the end prize. And this ended up on a judge's docket, okay, because they had to figure this out. And this is one of the, we talked about, I look at this from a lawyer's perspective. How do you write those rules, right? So it's very generally stated, whoever can birth in 10 years. But then when it started to be in court, you have some intelligent lawyers and they're trying to knock holes in each other's cases so that their client can win. Well, that woman has 9 children, but they're not all from the same man. Or she's trying to claim a stillborn or a miscarriage or, all of these situations where when you're writing something like this, you're not thinking all the way through, right? And we run into these problems all the time. And I always say, we have some long documents that we give people, and people say, why does it need to be that long? Well, because we got to cover every potential scenario that could come up so that there isn't a question of what would be done. Because the moment there's a question, we end up with the judge deciding. And I don't know about you, but the last thing I want is my property and my future and my family's future decided by some judge I have no relationship with.
Yeah, and it is very much driven by the language. And this will probably come up again as we talk about some more examples, but the court is willing pretty much to honor the wishes of someone who's passed regarding their life's savings, regarding their estate, but within limits, and meaning that the court will not enforce anything that they think is contrary to public policy. They will not enforce anything that is just totally frivolous and completely wasteful of resources. For example, someone could not write in their will that they want everything that they own to be put in a pile and burned, including the money. Those are things that it's just contrary to public policy and it's frivolous. And similar things that are intended to harass others or require others to do things that are not in their interest either. So, famously or infamously, you learn that cases where someone is forbidden to marry, that is an example of something that's considered contrary to public policy. Mm-hmm. Now, in this case, the idea of having children, that would have been enforceable. I think if you put that in a will today, I think that almost every state would enforce that because it's consistent with public policy. It's not contrary to public policy. I think that a provision that said that someone cannot have children, I suspect that would not be enforceable in many, if not all, states.
He had a substantial estate, too. So the 4 women that had those 9 children each split the money and were able to raise those children well because they had one. But he had also, he was a lawyer, okay, so it makes sense why he was able to write this in a way that it didn't get thrown out, right? And he wrote a couple other funny things. He was a funny guy. I mean, he used to do this thing where he had a lot of money and he didn't know where to go with it. And so he would put dollar bills on the sidewalk and he would hide behind a bush and watch people pick them up and be all excited and put them in his pocket. But he had 2 other provisions in his will that I thought were interesting. One is I mentioned he was a brewer, right? And he had a racetrack. Well, as his little joke, he left both of those to a group of prohibitionist Protestant ministers. Okay, so now the brewery is being owned by some prohibitionists. I don't know how long it lasted thereafter. I can imagine not very long. Another was, and this is lawyers' relationships with each other, right? We have a special bond, even when we go up against each other in court. A lot of times it's not personal; it's for the client, right? But sometimes some things sting, and you end up resenting another lawyer for a period of time. And he had 3 friends that were lawyers, and they did not get along. They hated each other. And so he had a estate in Jamaica that he left to the 3 of them. as co-owners, with the stipulation that they had to live there together if they were going to take the property.
Something tells me that they didn't take that property.
They would have what we call disclaimed, right? They would have said, I'm not going to own that. I'll pass on that. It'll go to whoever else would have received it.
Yeah, I can see where maybe all of those provisions would be enforced today, given the criteria that I just discussed. The thing with the prohibitionists, I mean, yeah, I don't see where that's frivolous or wasteful of resources or any of those things that courts would blow off.
They had an interest in it.
So the lesson here for our viewers is you can do a lot and you can have some fun in your will if you're of that personality type, but only within limits. And that's something that the court has dealt with, for a number of years. So the good news is, there's lots of case law over the last 200 years dealing with provisions in wills and whether or not the court thinks that it's in the public's interest or society's interest versus the interest of the deceased to enforce that particular provision. But for the most part, again, I want to come back to the initial consideration of courts, and that's that courts do want to try to defer to the wishes of someone regarding their own estate, as they've gone and expressed that in this solemn document called a will. So anyway, we'll move on. Sandra West, female here, American socialite.
Yep.
Tell us about her.
Well, she married a Texas oil tycoon, okay? And he passed before she did. She actually had a really sad passing. She overdosed. She was a Beverly Hills socialite that did quite a bit of partying after her husband passed. But she had a really specific provision in her will. And going back to what we talked about with Jeremy Bentham and the ability to determine what happens with your body, right? This is what
now let's insert. So this is in 1964. Do we know how long she'd been married to this guy?
I didn't get the length of the marriage. It must have been long enough for her to inherit all of his. We didn't get into how his was distributed. Now, interestingly, she must have had a pretty good relationship with the family because she named her brother-in-law, her deceased husband's brother, as her executor. So he's the one that actually followed her wishes. And so what were her wishes? And I quote, you'll understand in a minute why I quote followed her wishes. What her wishes were, she had this beautiful blue Ferrari, okay? And she wanted to be buried in the Ferrari in a lace negligee, leaned back in the seat, okay? That's how she wanted to be buried. And so what I found was a report from a journalist in the 1970s who actually attended the funeral, okay? So 64, it took a while. This was fought in court, right? It determined that this had to be done. And so he said he's standing there and he watches the funeral procession come. The first is the funeral home limo. Next, right behind that, is a truck-mounted crane, okay? And then a flatbed truck with a large wooden crate strapped on it that we are told the Ferrari was in, okay? Now, this is where my spidey senses start to get suspicious, right? So nobody sees the Ferrari. It's in this box. And then the crane puts it in the ground. And then they dump concrete over the whole thing, saying that they're trying to avoid grave robbers. Who's getting a car out of a grave?
So now I can buy the argument that if you had a Ferrari buried, that would definitely, you'd find pieces disappearing. But I just wonder about the cost of this burial. So assuming that the Ferrari was in the crate, which it was apparently testified or someone certified that this was the case. And then it was in this box, the box was lowered, and then you had the concrete poured in. Is that right? Poured over the box.
That's right. Locked it all in place for however long the concrete will last. It's a beautiful Ferrari, the pictures of it. It reminds, if you ever seen Ferris Bueller's Day Off, it's like the red Ferrari in there, except it's a baby blue. It's gorgeous. But it's the brother, it's her husband's brother, Sol West, that ends up being the one that does it. And so, I don't know. I just felt a little suspicious about how this was handled.
And so the person who attended didn't see the car.
No.
Yeah.
Just the wooden crate.
Well, the temptation would be irresistible to not put the car in there.
Right.
But this is something, incidentally, that a judge probably, I think, would enforce. I don't think it crosses that line. There may be a few judges that might think it's too frivolous or wasteful. But wouldn't you think most states would enforce this?
Yeah, there's a substantial estate there to pay for it. The state's not paying for it. It's her last wishes. Like you've said, they really want to honor people's wishes. They're their wishes, and it's their property. There's something that comes up when we're doing estate planning, and as people start to get older, and there's this temptation of the next generation to start seeing their ancestors' property as they're starting to make plans for what they're going to do with that property. And something that's really apparent to me, and the courts agree, is that it's not. It's the property of the decedent, and they earned it or they received it, and they get to determine what happens with it within reason.
Within reason. No, you're right. So now that may hold the record for the most expensive burial.
I got photos of it too. I found a news story, so I'll post them.
Oh, do you have photos of the actual burial? That's great.
All right, moving along. Karl Lagerfeld.
Yep.
Tell us about Karl.
Somebody people are more modern day familiar with. He was the designer for Chanel and Fendi, right? And so he had a long career, a lot of property, okay? But later in his life, he really fell in love with one specific, what do I say? Well, it's a cat, okay? Her name was Choupette, and I'm trying to pronounce that, Choupette, right? And so he left a large portion of his estate to Choupette. And another one, he was never married. He was married, but they never worked out, never had kids. There was a lot of ideas about his personal life that I won't dig into here. But he left a certain amount of money, I think $3 million, to that cat. And for that cat, funny enough, I'm thinking, wow, $3 million. That cat at his passing was already worth more than $3 million. She had a book deal. She had done some advertising. I mean, he really, he had two housekeepers that took care of the cat. It got fed meals. There was certain restaurants that he would go to that there was not just a meal they prepared for Karl, but a special meal for Choupette.
I'm looking this up right now, and the cat has its own Instagram page.
Very famous cat. And so this may seem far-fetched, but not at all, right? We go to a will might not be the best way to handle it, but a trust is definitely. We do pet trusts probably more regularly than you would anticipate, right? And they're not always $3 million, right? But if you've got a cherished animal that you've spent a lot of time and that you love dearly, you can set it up so that you can name who's gonna be the caretaker, right? You can say who's gonna handle the money, how much you want to leave to them. You can talk about disposition of their remains, or if something were to happen where you'd want them to go. You can be real specific because an animal's personal property.
Mm-hmm. Yeah, and you are right that pets now in the Uniform Probate Code and Uniform Trust Code, there's now provisions for people to provide for their animals. And at one time, there wasn't any formal way to do this. So the way it was done would be that there would be someone who would be given money, and then there'd be an expression of a wish that they use that money to take care of the animal. But it wasn't legally enforceable up until these changes in very recent decades, maybe over the last 10, 15 years. Now you find it in maybe all states where you could actually create a trust, as you said, a pet trust, and it will be enforceable. There will be someone charged with responsibility to take care of the animal. There will be a trustee to manage the distribution of funds necessary for that. So now it definitely can be done, and the person can be confident that the just like you could for a child, you can be confident that your animal that you love so much is going to be well taken care of. However, the courts have come down in several cases where they've said that there was an excess or a frivolous amount left. In other words, the court is honoring the intention of the person who leaves money to take care of a pet, to give it a great life. They will honor that, but when it's an amount that just calls for money to be just frivolously spent, then they will provide that the necessary funds for the cat to have the standard of living that it or dog or whatever, to have the standard of living that it had known that the owner could reasonably have expected. Once that amount of money is provided, then any excess the different states deal with it differently. It can be regarded as money that is not otherwise distributed, so it goes into what's called a residuary clause, or it could go to the remaining beneficiaries if it's a trust. Mm-hmm. So there are ways to where the money does go to those that the person who's died, the decedent, cared about, and it does take care of the decedent's desire. And the decedent's desire, the court would look at what is the underlying intention, and the underlying intention is to have the pet, we'll assume, very well taken care of. But when it goes beyond that, then you're back to kind of a public policy thing. If someone leaves $25 million for their dog, because maybe they have no one else in the world, so they leave $25 million for a dog to be taken care of, and say the dog's reasonable remaining life is even 10 years, but certainly less than that, there's just no way to spin that in any way except to do it in just grossly wasteful ways. Mm-hmm. And the court would at that point intervene, but oddly enough, they're not intervening with the real intention of if you think about what the driving motivation was, the court's not interfering with that. And so that you do see that, because there have been a number of cases where people have left too much money, for an animal. Right. And it's just not reasonable to use it.
Well, and you got to look at all those factors you brought up, right? So Karl doesn't have anybody that's being disinherited by this. He left 9, 10 other people a substantial amount of money. None of them were his relatives. They were protégés and people he'd worked with over his time. But also something that you're very familiar with divorce law, which you just brought up, that standard of living, right? What is the life that the cat was accustomed to? And I don't even know if the $3 million will cover the life that the cat was accustomed to. Luckily, she's got a couple jobs of her own, right? And so she's out there. But the one thing I wanted to bring up is that trust, and what a concept people have a hard time with is well, why can't I just write it in a will, right? If I can do it through a trust, why can't I do it through a will? A will is going to make distributions through probate, which, I mean, don't get me wrong, probate lasts longer than I would want it to in many circumstances, but it doesn't last forever, right? And so when you say I want this to be held for the cat as long as it's alive, well, we don't want to keep a probate case open as long as the cat may live, right? We don't know how long it's going to last. And that's where that trust really comes in, because you don't need to know, right? This trust will exist. We've got that entity created. We put somebody in charge of it. It's outside of the court, so we're not waiting for a judge to determine whether the $3 million for the cat is reasonable or not. And that can maintain as long, and then you can say what happens to it thereafter. So it's, for those that are interested, the real way you can use a trust to really reach beyond to control things for a pretty long period of time, as long as, like you said, it doesn't overcome public policy, right? At some point, it's not outside the law. It can always be challenged, but it wouldn't be in court right away.
Yeah. And if you look at the history of this statute now, that has become more accommodating to a society such as ours, where pets are treated in some cases like children. In any case, people really like their pets. So the laws evolved to accommodate that. In the early versions of this statute with the trust code that you commonly saw there was a number of years limit. And I'm sure it probably started to where it was 5 and 10. I know that the last limit that existed in a number of states before the Uniform Code come to where it is now, and it was 20 years. And you'd think, well, gee, 20 years is plenty of time. And it was plenty of time for 90% of the animals, or maybe 95. But then you have those people who have very long-lived dogs. You have people who have very long-lived cats who seem to make it past 20 in more cases than you'd expect. And then you have other pets. So I don't know. At one time, there was a 50-year outer limit. I'm curious to check this. But in any case, now it's that the pet has to be alive when the person dies. So it can't be a case where you're providing for an animal and that animal, let's say, has kittens or has puppies, and then you want those covered. The way that the statute's written in most states, and the Uniform Trust Code anyway, is that it provides that for a life that's in being, so to speak, a pet that exists, you can provide up to the balance of that pet's life with no limit on that. But floating in the back of my mind was a 50-year limit, but I think that's been ditched. That was probably the last point before we got to the present law. Do you remember, John?
I don't know the specific limit that exists. All I do know is tortoises live 100 years, right?
Yeah.
I remember at one point, my one daughter wanted a box turtle, and I was looking at them, and the guy at the pet store said, oh, yeah, these can live 25, 30 years. And I looked at her, and I was like, I don't think we're ready for that type of commitment.
Yeah. No. So yeah, you have to have provisions, though, that allow for animals that are long-lived. So, John, this has been a good discussion. And, I have to tell you that when you first suggested that we do this, I was thinking that, well, I can certainly see where it's going to be interesting, but are there learning opportunities? And I see now that as we've walked through these 5 examples, they're not only are these strange and fascinating, but there are things that do correlate to things that affect the lives of our viewers.
And when we're talking to people about their estate plan, we're dealing with everyday problems, right? And that's what a lot of these situations really highlight is, real people, real problems. And if you don't have a family, if it's not clear, what happens then, right? And that's when a lot of times they get more exotic.
Yeah. So this is a good discussion. We're going to have to do this again. Today we talked about 5 interesting wills. So we'll circle back and we'll do another group of 5 at some point in the future. So this has been another episode of Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell and Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.